Last year, San Diego police officers responded to a mental health crisis in the Gaslamp district and ended up restraining a man on his face, pulling his legs up behind him, and applying downward pressure until he suffocated and died. This kind of death is called positional asphyxia, and it's been widely known in law enforcement circles since at least the 80s that it's a very dangerous way to restrain people, and it often leads to death. The San Diego Medical Examiner ruled that the killing was in fact a homicide. The District Attorney's Office, after reviewing the incident, has said that no criminal charges whatsoever will result against the deputies. Is this surprising? Unfortunately, no. Disappointing, but not at all surprising. According to the most recent statistics, there were over 1,200 police-caused deaths in the United States last year. Of those, well less than 1% resulted in any criminal charges whatsoever. If we're waiting for district attorneys and prosecutors to police and to consistently bring criminal charges where they are warranted, I think we're all going to be waiting for a while. The system is simply not set up to do that. In fact, I would argue it's set up to do the opposite. The reality is that prosecutors and district attorneys will almost never bring criminal charges against the police. It's just not what they do. That's where civil rights attorneys and private civil actions come into play to seek justice. When there's that many deaths, that much violence in the street between police and the people that they are policing, and when that few are ever brought to any sort of meaningful criminal account, something has to change. And that kind of change is what civil rights attorneys like us at Mackenzie Scott are trying to accomplish when we get involved in a case like this.